I have for you gifts. Actually, I do have some leftover cookies if you want. But these are much more nutritious. They're Constitutions. Pocket Constitutions. Please take one, bring it to class every day. A little heavy. Maybe you want to break them up. Thank you so much. Please bring it to class every day. Treat it with value because it's worth a lot. Maybe at $1, but it's worth much more than that. But this is my gift to you. I hope all of you read it in its entirety throughout the course of this semester. The second thing I want to announce is that we're going to be using clicker apps in this class. Now, how many of you use these before, either in college or undergraduate? How many in South Texas? Okay, now I see that about 20-something of you have downloaded the app. What's with the rest of you? Do it now. This is when we use to take attendance. So you can either use your smartphone or your laptop. If you have neither, you can talk to me after class, but this is going to be an important part of the class. So everyone download, do it now. Take out your phones, your laptops. The name of the app is Reef iClicker. Yeah. Reef iClicker. Okay, download it. I think it's like $14 a semester. It'll be worth it. Trust me. Register an account. It should take a minute. And after you create an account, select South Texas College of Law. Okay. When you log in, select South Texas College of Law, then select the class, Constitutional Law with me, Josh. Then when you log in, it shows your attendance.
Is this app like the standard for the university?
Yes, other professors use it.
Go ahead and buy the 3-year package or 2 years?
That's up to you.
Okay.
I wouldn't tell you what to do, but at least you'll be using it this semester. I can't tell you if other professors will use it, but I'm using it.
Field uses it.
Who?
Field. We're having for evidence next semester.
Okay, then buy the year. Do whatever you want. Your call. I always have difficulty telling students to spend money on anything because I know it's tough. Once you log in, you'll see an option for attendance, and then you check in. The way this is going to work this semester, to make sure you guys don't come late, is I'll have this running, and then at 2 o'clock on the nose, I'll turn it off. So mark yourself present. Don't try to check in from outside the classroom. I'll find out, I'll know, and you'll get in trouble. There's actually a feature where you can limit it by GPS, that if you're not in the building, it won't let you work. I don't enable that because a lot of students don't use a GPS feature on their phone for privacy reasons, which is not unreasonable. So I won't have that restriction, but don't fake it. Anyway, okay, so I see now 35 people have checked in.
How do you check in? How do you just...
If you close out the app and come back in, you'll see it. Okay? I'm here. So Taylor, Jason, Eric, Aaron. You haven't checked in yet?
Yeah.
I'm taking a minute to do this now, so we don't have to worry about this later. Has anyone not been able to download the app? Has anyone not been able to create an account? Okay. I'm going to make sure everyone does this because I don't want to do this again. I have 35 people checking. I have more than 35 students. All right. Is anyone having any difficulty still? Raise your hand. Just one? Okay. Take your time. I don't want you to rush. Trust me, you'll like this. The quiz feature, ungraded, I say quiz, you just ask questions, but it's a very good tool for whatever.
Everyone have a constitution.
Everyone have a constitution? Anyone need one still?
Professor Blackman?
Yeah.
Should we just pull the app up on our computer?
You can do it on a computer or your phone, whatever you want. I don't care. There's a web browser version. If you go to the iReef website, it's also on your phone. It makes no difference. Thank you, sir. All right. Dan, you good?
I'll get it in a minute. I reset my password. I'm trying to log in.
Okay. All right, so I have 36 people checked in. Most of you did it. I'll leave this open for a few more minutes, and if for whatever reason you don't get it, come talk to me after class, okay? Right, if you don't, cool. All right. I now want to go over the syllabus because I did not have an opportunity to do so last week or last class. I really feel the need to go through the entirety of the Constitution on the very first day of class because the simple fact is we won't have time to cover it. We spend an entire semester on literally 7 or 8 clauses of the Constitution. It's strange to think about it, but so much what we do is focused on things like the Commerce Clause, the 14th Amendment. So I want you to be exposed at least once to all of our founding documents. So by now, you've all seen the textbook. You now have your pocket constitutions. There's also going to be a supplement. If it's not available for sale yet, it will be soon. I'll also email you various PDFs, but I think you have all the reading materials. Also, I note we are in the process of revising the 2nd edition of the textbook. The 3rd edition will be out in January. No help for you, but if you find any typos, any errors, tell me, because I can get them fixed, because we're in the editing process now. The class will have a final exam, 3 hours, completely open book. Bring whatever you want. It will not help you. And I mean that sincerely. It will not help you at all. All of my old exams and midterms are posted online along with an A+ answer. The reason why I do this is because I want you to actually take the old exams. Not look at them, not review them. Take them 90 minutes at a time in a quiet room and then grade yourself. The reason why is that when you look over an exam, you're not helping yourself at all. You're not testing yourself. Midway through the semester, I think in the 15th class, we're going to have a midterm in class. 90 minutes, 1 question. I will grade it within the month. And throughout the month of November, I will make an appointment with every single one of you to come meet with me at your midterm. These are not optional meetings, they're mandatory. And the way I ensure this is you schedule your time before you get your grade. Because invariably what happens is students who do well, like, oh, I don't need to meet with them, and students who do poorly, oh, I'm embarrassed. So all of you will make an appointment with me at some point in November. There'll be plenty of time slots, don't worry. Fortunately, this term I have small sections of 50 and 60, so it's not so bad. So you'll be able to come and meet with me. The reason why we do this midterm review and the reason why we do this clicker app thing is to give you as much feedback as possible before the final exam. Traditionally in law school, the only feedback you get is when you get your final grade, which is not very helpful because that's too late. So South Texas, we're trying to push forward and give you feedback earlier in the semester rather than simply at the end of the term. So that's why we're doing this. The clickers, I'll be asking questions throughout the course of the semester. Those are designed to test your own knowledge. I'm not grading you. There's no right or wrong answer. You're not going to get points off. This is for your own benefit. In terms of attendance, we'll be using the clicker app for attendance. If you do not have a clicker or a laptop, come see me after class. We'll work out something else. Sometimes it's maybe 1 or 2 students, but usually everyone has it. In terms of office hours, if you want to meet with me, right before this class from 12:15 to 1:15, I'm free. If you want to meet afterwards, after 4, that's fine, although students usually want to get home after 4 and beat the traffic, so you can come whenever you want. Do you have a class before this? This is your first class of the day? Way over. Okay, so you're already here, so you'll probably come at noon. That's fine, I'll be around. In terms of interacting with me, I am very good with email. There's an address there. If you can send it to that address and not the South Texas one, I'll probably get to it quicker. But I have a special filter that flags you guys to the top of the list. All of my lectures are on YouTube. Every lecture I've ever given. In fact, that little thing right there is live streaming it right now. I encourage you to, yes, the magic, right? I encourage you, it's like an alien, like an H.G. Wells monster of some sort. I encourage you to take advantage of this. What a lot of students do is they will watch the lecture from last year before coming to class. That prepares them for what I'm going to ask. I'm not that original. Odds are, if I ask a question today, I probably asked it last semester. And you can look really smart by knowing the answers in advance. And I'll give you a hint. I'll give you a tip. YouTube lets you watch videos at double speed. So you can watch a 2-hour lecture in 1 hour. There's a little gear icon on YouTube. Click 1 speed, 1.5 speed, 2 speed. You can blow through it quick. Some students listen to it during their commute or whenever they're driving to school or whatever else. So I encourage you. Also, when you're sitting here in class, I don't want you to be typing what I'm saying verbatim. Fortunately, none of you are doing that right now, which is good, but that will happen later. I would much rather you sit and listen and you understand what I'm saying. Think about it. If you miss something, go back on YouTube and watch it later. Say, oh yeah, even in your notes, write down minute, at like 1:35 or 2:35, and go back to the time slot, and you know exactly where it is. That way you can fill in the gaps, whatever's in your notes. Use this for thinking and adapting, not just for clacking on your keyboard. It won't help you. So watch the old videos. One note, though, it's going to drive you guys nuts. I'm sure some of you know this already. I change your syllabus around a lot. Yeah, you guys are smiling. I rearrange a syllabus significantly this semester. So for those who are using notes from last semester, they're not going to help you very much. They're going to drive you crazy. You'll still be able to figure out what cases are when, but it's going to be hard for you to use old outlines. In fact, my very first semester teaching ConLaw, I actually had a student complain and said, it's really hard to go to your class because all the old outlines, there's nothing available for you. So this semester will be a little bit tricky. The syllabus lists each date of the semester and what's going to be covered. I take it as a point of personal pride that we cover what we say we're going to cover. I don't fall behind, ever. I have not fallen behind in 6 years. So whatever is going to be on a given day of reading, that is what's going to be on a given day of reading. There's not going to be any deviations. We start on time, we finish on time, I won't keep you late. The flip side of that is you have to do the reading. There's no stay 20 pages ahead, it's read those pages. The way that I conduct recitation is probably different than what you're used to. Everyone's on call every class. And what I do is I go up and down the rows. I'll start with maybe Benjamin, and go along the back, go to Evan, and then go to Adam, and then go to Boone, and then go like this, and then eventually get down to the front, and then I go right back to the top. This is a fairly small section. I can probably call about 30 or 40 of you in one day. So you all will be on call, and sometimes I jump around rows, so you can't try and time it. I move around a bit. It's not always the same pattern. So you're all on call. The course homepage, which I link to up here, it's hard to read, but it's right over there. It's like one of the third or fourth lines. Every day there'll be a new blog post which lists different pictures, different notes, different attributes of the case that I want you to discuss. Nothing too important there. One item that's worth studying is what I call my lecture notes. And here, I already loaded it here. Is my lecture notes. And right there. And if you click that, it's going to open up a Google document, right? Right here. And I will be typing in right up here throughout the course of the semester. You don't need to, copy verbatim, because if you click on this link, you can pull it up in your browser. And if you don't have a computer, you can click on it when you get home. But all the documents are available to view on Google Docs. And I will be putting questions and other notes here. If there's a clause of the Constitution that's relevant, I will put it up here. So even if you have no computer, that's fine. Look up here. And I got that screen fixed. We spent 30 minutes with IT, but we got it fixed. It took a while. You're welcome. Okay. Do all of you have your name tag cards? Mm-hmm. Did some of you lose them already? What's your name? Jackson. I probably have yours up here. All right, I'll tell you what, Jackson. Write in a big marker your name. Just pass this back. Anyone else not have a name card? Yeah, if you have a Sharpie, beautiful, perfect. Get in big letters, big bold letters, so I can see it from far back here. My eyes get weaker every semester I teach. There's a great story involving George Washington when he was a general of the Continental Army, and there was actually a proposed mutiny, and people were actually thinking of overthrowing him because they had no money, they had no requisitions. And there's this one great scene, which is probably not true, but history says it is, where Washington gets up there and he takes off his glasses. He says, you know, forgive me, my vision has weakened in service of my country and serving my people. And like people are going, aww, and then the mutiny just fell apart. So I will put my glasses back on now. Okay. Any other questions? Anything on your mind before we get started? Mark.
Did you indicate that you'd be shutting down the attendance clicker at 2 o'clock on the nose?
Thereabouts, yeah.
Okay.
Yeah. I'm going to leave it open for, well, now I'm going to turn it off, but I left it open for 15 minutes. But I want you guys to be on time. It's not only for my benefit. I don't care as much, but a lot of students object when people come in late and they make a commotion and it gets distracting. I've had complaints over the years, so this is my new way of using technology to eliminate that. Yes?
Your previous lessons, I can't get closed captions on them, but the one from this semester, I can get closed captions. Is it something I need to do? Or
No, I don't. I think my fancy new camera allows it.
Really
How are the captions? Any good?
Yeah.
Are they accurate? I haven't tried them yet.
Some words here and there, but I can think them out.
This is a fancy new camera. It might have a better audio quality.
I like the closed captions.
Good, yeah, if you have closed captions, you can zip it even quicker. But thank you, I didn't know that. Yes?
I had an issue looking at the answer for your exams. I was able to see all the questions, but not the answers. So I didn't know if they were in a different place.
So the link for the A+ answer, you click that didn't work?
Yeah, it was.
Can you come up after class and show me? I don't want to spend too much class time, but I'll take a look at it. Okay, Brandon.
The copy that says the lecture notes are here, do we have that yet? 'Cause I don't
Yeah,
see it on mine.
if you click that link.
I just don't even see it.
Yeah, it's not.
It's on, if you go under constitutional law instead of looking under syllabus.
Yeah, if you go
Those
to,
three-
here, I'll show you.
It says constitutional law, syllabus, lectures.
So, yeah,
Go to
if you
the
see there's a link for classes up top, if you click this classes link, there'll be a link for constitutional law, and that'll get you to it.
Okay. I clicked on syllabus instead.
Yep, no, that's fine. I usually do this in the first class, so I will gladly spend a few minutes doing it in class number 2. Okay. Anything else? All right. All right. So I'm going to shut down the attendance thing now, and I want you guys to start your first question. Okay. So take out your. Okay. And if you weren't able to sign in, come talk to me after class. I'll mark you present. Okay. All right. So I'm going to start a polling session, and your question. Oops. Okay. And your question is this. It's a true or false question. Are the decisions of the Supreme Court the supreme law of the land? And A is true, B is false. That's your question. Are the decisions of the Supreme Court the supreme law of the land? 21 people, 23 people, okay? Are the decisions of the Supreme Court supreme law of the land? I'll stop it in another 10 to 15 seconds.
B is false.
Yeah, A is true, B is false. That'll be the rule for the semester. I think I'll mostly ask true or false questions. That way you guys can't skim. You gotta take a stand. There's no maybes. All right, 5 more seconds. True or false? Okay, stop it. Let's see what we got. Okay, and check this out. Is it ready? Results. Whoa!
That's not good.
That's pretty close. That's pretty close, right? True or false? Okay. So in our last class, I walked you through the Supreme Court. I walked you through the Declaration of Independence, the Articles of Confederation, and the Constitution. And if you notice throughout that entire discussion, I tried really hard not to mention any cases. I slipped like on 3 or 4 occasions. I always get mad at myself when I do that. But what I want to show you is that we have an entire body of law before the Supreme Court even existed, right? That before the Supreme Court, before Chief Justice Jay and his colleagues met for the first time, we have law. And it's a fetish of law students, and I use that word lightly, to say, oh, whatever the Supreme Court says that's the law. That's not always the case, and you know this implicitly, because there'll be some decisions you agree with, and there'll be some decisions you disagree with. The Supreme Court's certainly final, but they're not always right. And I think this decision, which that's pretty close. I mean, 56, 54, 46. Can all of you see this graph? Yeah? Good. I like it. It's instant feedback. And I think this is a testament to that. Now, one of the reasons why a lot of people have this idealized view of the Supreme Court is because of the first case we're reading today, Marbury versus Madison. Now, how many of you have heard of Marbury at some point before class today? I think all of you, right? And how many of you were taught in primary school or high school or whatever, or college, that Chief Justice Marshall, who wrote the decision in Marbury, invented the concept of judicial review? How many of you were taught that? How many of you were taught that judicial review existed before Marbury? Okay, so for those who've even heard of it, you were all taught the same bit, that Marbury and Marshall invented judicial review. And it's simply false. It's one of these myths that if I have any role in this world, I will destroy, because it's not true. The English common law courts have had the notion that laws contrary to the English Constitution, which are unwritten, are void. We read in Federal 78 for your first reading last week that laws that are laws that are contrary to the Constitution can be set aside by the courts. Indeed, much of Marbury, John Marshall just plagiarized from Alexander Hamilton. Ditto from McCulloch, Maryland, just plagiarized Hamilton, which is fine. But the reason why Marbury holds such a central place in what's called the constitutional canon, like the canon, not things you shoot, but it's a body of cases that are considered very important, is that it was the first time that the Supreme Court used its power of judicial review to set aside, that is, to invalidate a law. But to understand Marbury, it's not about a routine statutory interpretation case. The politics that gave rise to this case are simply stunning. So let me give you, before we even get to the facts of the case, the background of the decision, which is very important to grasp. We all know, or at least we should know, that our first president was George Washington. He was basically elected unanimously, the general of the Continental Army, this paragon of virtue. Washington had no party. He wasn't a Republican, wasn't a Democrat. He was George Washington. Washington was re-elected in 1792 for his second term. And even in 1792, there wasn't really a party system, but there was growing dissatisfaction, people who were against the incumbent administration. Imagine that people opposed to George Washington, right? We were never happy as a people, right? But then we get to 1796. And this was the first election without George Washington. Washington learned to say goodbye, as the lyrics in Hamilton tell us, and he did not run for a third term. The election then came down to two men, John Adams, who had been the vice president under Washington, and Thomas Jefferson, who had been a Secretary of State under Washington. These two men hated each other. Adams and Jefferson absolutely despised one another. They had been friends earlier in life, but here they really and severely disliked one another. In 1796, John Adams won the election. Okay? John Adams won the election. Under the rules in effect at the time, the person with the second most votes became the vice president. So you had this administration with John Adams as president and his vice president, Thomas Jefferson, and they hated each other. They did not get along at all. The Adams administration was not particularly noteworthy. They had some stuff we'll talk about later. But we fast forward now to 1800, the next presidential election. Adams had no shot. He wasn't very popular. So then the election came down to Thomas Jefferson and a man named Aaron Burr, sir. You may have heard of Aaron Burr from maybe the Hamilton musical, but he is perhaps most famous for killing in a duel Alexander Hamilton. the Electoral College vote tied between Aaron Burr and Thomas Jefferson. When there's a tie in the Electoral College, the House gets to pick the president. Each state in the House gets a single vote. And at the time, the House was pretty evenly split between the Federalists, who was the party of John Adams, and the Democrat Republicans, the party of Jefferson. And there was one ballot, another ballot, another ballot, and they kept tying. And they couldn't pick who would be president, Thomas Jefferson or John Adams. This was a significant crisis of the highest order, because if they couldn't pick a president by the inauguration date, we'd have no president. And actually the vice president would have served, which probably would have been Burr from the Senate. Eventually, after a number of ballots, the House picked Jefferson to be president. The rumor, and who knows if this is true, is that Jefferson offered some guy in Delaware a position as a lighthouse manager, some sort of the Coast Guard. He basically bought off the vote. So Jefferson was picked. But with that, you now had a lame duck president, John Adams. And Adams's party, the Federalists, they were destroyed, right? They were wiped out of office. They would never again return to power in the United States. So John Adams and the Federalists did what any party on the way out the door did. They tried to entrench their power. And they did this through the judiciary. So at the time, John Adams had a Secretary of State. His name was John Marshall. Yes, the same John Marshall. I went to a wedding last weekend in Charlottesville, and on the way down there, I drove through Fauquier County, Virginia, and I went to John Marshall's ancestral home place where he was born. There's like a marker in the woods about a mile from the road. So I went there and I paid my homage to the great Chief Justice, or something like that. At the time, John Marshall was Adams' Secretary of State. A vacancy arose in the Supreme Court. Adams appointed Marshall as the Chief Justice of the United States. Wait a minute, Josh, how can you be both a Secretary of State and the Chief Justice? There's no problem. The incompatibility clause says you can't be a member of Congress and serve in the executive branch, but there's no problem with a member of the judiciary also serving in the executive branch. It's actually not problematic. President Obama could have appointed himself to the Supreme Court on his way out. That would have been perfectly fine from a constitutional perspective. That was a brief rumor, but didn't go very far. But that wasn't the only judicial appointment that was made by Adams. There were a number of lower court judges that Adams put in. These were called the midnight appointees. And the reason why they were called the midnight appointees is because they were literally made at the last hour. On his last night in office, John Adams signed a number of the commissions for these new appointed judges. John Marshall, who was the Secretary of State, stamped them. And with that, Adams went to sleep. He actually went to sleep early because he wanted to get the heck out of town. He said, I cannot stand to see Jefferson inaugurated. He left like at 5 in the morning. He got out of town quick, right? He bailed. But the problem with signing these papers and sealing them so late was that they had to be delivered, right? The way you got a job back then is you have a president sign your commission, you'd have the seal of the United States, this big wax seal, and that'd be delivered. You know the Stevie Wonder song, Signed, Sealed, Delivered? I'm yours, right? That's how you get it. Marshall, though, had so many commissions to deliver that night, he didn't do them all. In fact, it was Marshall and his brother, who also became a federal judge. They were unable to deliver all the commissions in time. So the next day, Jefferson comes into office, and he tells his new Secretary of State, James Madison, right, that's the marvelous Madison, hey, James, how about you don't deliver any of those commissions, and let's put our own judges on the bench, right? Let's not put these Federalist judges, let's put our own Republican judges on the bench. So then poor William Marbury, right, who had been nominated to a court. He was a justice of the peace in the District of Columbia. He'd been confirmed by the Federalist Senate. His commission had been signed by President Adams. It had been stamped and sealed by Secretary of State Marshall, but it was not delivered in time, right? So these are the facts that gave rise to the iconic case of Marbury against Madison. But the facts don't even come close to describing the significance of this decision. Okay, so now I start calling up people. Benjamin, you're up first. Sorry, you're in the hot seat. What did Marbury do? Because he didn't get his commission, what did he do? What did William Marbury do?
I don't know.
I'm sorry?
I'm sorry, I didn't get to read it last time.
You didn't do the first case? Why wouldn't you read for the first day of class? Don't do that again. Jessica, what did Marbury do? Okay, he sued James Madison, right? First off, where did he sue him? Which court? He sued him in the Supreme Court, and what did he seek? What was his request? What was his relief that he wanted?
He wanted his commission by a writ of.
Exactly, okay? So what he wanted was, he wanted his damn commission. He's like, I want my job, right? I got this cushy job. I want to be a judge. I want to wear a robe. Give me my commission, okay? So he sued in the Supreme Court for what's called a writ of mandamus. A writ of mandamus, right? A writ of mandamus is an order to say you deliver something. In this case, it was his commission, okay? Now, one of the basic principles of any court is a court can only take action where it has jurisdiction. Right? A court can only take action where it has jurisdiction. If a court has no jurisdiction, the action must be dismissed. Right? So Daniel, where did Marbury see jurisdiction being present? Like, what gave the Supreme Court jurisdiction in Marbury's mind? Of? Okay, it's on the board. And what specifically about it? What did this provision allow that Marbury was relying on? Writ of what? I'm sorry? Mandamus. Very good. Yes, sir. Okay. So Marbury goes, look, we have here the Judiciary Act of 1789. This was an act enacted by the first Congress, right? James Madison, all those guys who wrote the Constitution, they wrote this Judiciary Act of 1789. And it provides, it's a long excerpt, but I'll give you the money quote. The Supreme Court has jurisdiction to issue writs of mandamus to any courts or persons holding office under the authority of the United States. Okay? So what's the problem, right? Daniel, can the Chief Justice, can the Supreme Court issue a writ of mandamus under this provision, this Section 13? Does the Supreme Court?
They can't issue one.
Why not?
They can review it.
Okay, so let's unpack this for a minute, right? The Chief Justice's opinion, Chief Justice Marshall, for all of its importance, is also very easy to read. Everyone knows it's a very easy opinion to read. He lists 1, 2, 3. Yeah, it's like almost an outline. To get to the final conclusion, there are 3 questions that Marshall poses. First, does Marbury even have the right to a commission in the first place? Second, if he has that right and the right has been violated, does the law afford him a remedy? But then the third question is the most important. If the laws afford him a remedy, can it be given in this court, the Supreme Court? Right? So the first question is largely edited out of your casebook. I debate whether to include it, but readings are long enough as they are. It's a real struggle when you're editing a case, what to include and what not to include. I didn't quite appreciate this until I started editing a book, but it's a tough question because every single paragraph you add, you make students angrier. But every paragraph you delete, you're omitting something from the student's knowledge. So what I do up here is I fill in the gaps of what's not in your case. So I'm saving you reading, but these are still things you have to know. This class is part of your assignment as well. So the first part of Marbury's opinion, of Marshall's opinion, is asking, does Marbury have a right to the commission? And he comes up with, I think, a fairly persuasive argument that he does. The final act under the law was not delivery, but the putting of the seal, the sign and seal, right? The delivery was optional. And he uses this one example, which I think is actually very good. What happens if Marshall had delivered the commission and then the guy's house burned down and he lost his piece of paper? Does that mean he's not a judge anymore? Or does that mean he requests a copy of the record? Of course, right? If you lose the piece of paper, you don't lose your job. You can get a copy of it. So from this basic principle, Marshall derives that, yes, he has this right, it's his, even though it's never delivered. But what's funny, is that Andre?
Yes.
Andre, what's funny about Chief Justice Marshall writing about the delivery of this commission? What's off about this entire enterprise?
Isn't that it was his job?
Say it again.
It was his job?
Yes! One of the first principles of being a judge, you should not be you should not be a judge in your own case. Under any conceivable standard of judicial ethics, John Marshall should have stepped aside. He should have recused himself from this case. Under any conceivable standard. He was the reason why Marbury did not get the piece of paper. It was his fault. Is that mentioned anywhere in the opinion? No, and even the parts we cut out for your reading pleasure, it was still not mentioned. So the entire case is messed up, right? Marshall should have never decided this case. But there's another aspect of this case that is not obvious, but I want you to focus on. I mentioned that Thomas Jefferson hated John Adams. You know who else he hated? John Marshall. These guys all knew each other, right? Marshall and Jefferson were actually cousins, distant cousins. They were in Virginia. The Republicans who swept into office didn't think much of Chief Justice Marshall. In fact, one of the first acts of the Republican Congress was they dissolved the Supreme Court's term. They said, hey, you guys, you can't meet this term. And oh, the way, you can't resolve Marbury's issue. They actually suspended the court's term for an entire year. Can you imagine that, right? Beyond that, the Jefferson administration didn't even send a lawyer to argue. The case is called Marbury versus Madison, right? James Madison, the father of the Constitution. He wasn't even there. He didn't even submit a brief or make an argument. This guy helped write the Judiciary Act of 1789. He basically wrote large pieces of Article 3 of the Constitution. He wasn't even there for the case because he didn't care. Why? Because Jefferson made it known that even if they ordered him to give Marbury his commission, he would not have done it. Whoa. Jefferson made it known that he would not comply with the order. Because in his mind, the Constitution did not require him to do so. And who is the Supreme Court to make me? Now this is a question to ask the outside the case. Is the Supreme Court the only body that can interpret the Constitution? Or can the executive interpret it for himself? Today we say, of course it's a court, but that's not so clear, and that's certainly not how Jefferson thought it. Jefferson thought that the president has his own independent obligation, takes an oath, to support and defend the Constitution. So Marshall knew that if he ordered Jefferson to issue this commission, it would have been ignored. And what would that have done to this young Supreme Court? To issue an order to the president, or actually the Secretary of State, and the Secretary of State ignores it. It would have made the court irrelevant. Who would follow a court if they're just going to be ignored? So Marshall was doing something else. Okay? He was right that the commission ought to have been delivered. He should have done it himself. But the rest of the opinion goes off the rails. And I don't want you to understand this opinion as a correct interpretation of constitutional law or statutory interpretation. It probably isn't. But it was written in such a fashion to avoid a confrontation with Jefferson. That is what this opinion is about. It's not a correct application of the law. I don't think it is. There are arguments on both sides. I think it's wrong. I think Marbury's wrongly decided in a lot of respects. But understand the context in which it was decided. Okay, so we did the first question. Right? The first question. Does he have a right to the commission? Yes, he does. But then, is that Jonathan? Jonathan, the second question. Do the laws give him a remedy? Not just the Supreme Court in general. Do the laws give a remedy to have this commission delivered?
So whenever there's an injury, every individual has a right to claim protection.
Yeah, I'm glad you used that quote. There's a very famous quote, let me see if I can find the exact quote. The very essence of civil liberty certainly consists in the right of every individual to claim the protection of the laws whenever he receives an injury. Let me read that again. The very essence of civil liberty certainly consists in the right of every individual to claim the protection of the laws whenever he receives an injury. What does that mean, Jonathan? Very good quote you picked out.
No person is above the law.
So if someone does a wrong, what can the person who's wronged do in response?
Ask for a remedy.
From whom? Who can he ask a remedy from?
The remedy's against the executive branch.
But who is he requesting to enforce this remedy?
Courts.
Courts, right? What's Marshall saying here? That if someone's wronged, they can go to the judiciary, and the judiciary can enforce their rights. That this is the very essence of civil liberty. Okay? Now, the court, right? The court doesn't say here that you can ask for anything, right? For example, let's say the president doesn't appoint me to the Supreme Court, right? I can't sue him. He's like, why didn't you appoint me to the Supreme Court? Right? I'd be a good nominee. But if it's a non-political question, right, where you already have a vested right, you already have this commission signed and sealed, that you can ask to have delivered. Okay? But that's only the second question, right? We already said before, I think it was Daniel said before, that Section 13 of the Judiciary Act of 1789 allows the Supreme Court to issue writs of mandamus. Okay? Elizabeth, what was Marbury's biggest mistake? He made a really huge mistake here. What should he have done? What was his mistake? He made a really big mistake. He could have fixed this case right up. What should he have done? Where did he file his lawsuit?
The Supreme Court.
Where should he have filed his lawsuit?
I guess in the state.
The state court, or? You're on the right track. You're exactly on the right track.
I'm not sure.
Where do appeals from the Supreme Court come from?
Appeals from the Supreme Court.
How do you get to the Supreme Court?
Yeah.
Okay, and what's below the appellate court?
The district.
District court, yeah. He should have brought his case in a lower court. They were called circuit courts back then, which is effectively what we call district court today. He should have brought his case in a federal district court. Right? Elizabeth, you're finish it up for me. Why should he have brought his case in this lower court? What would that have accomplished? Why would that have been a smarter move?
Because then it might not have been a constitutional issue.
Why not? You're exactly right. You're really close.
What?
Would Section 13 of the Judiciary Act of 1789 have given him a remedy had he filed this in a lower court?
Because I know that the outcome, it directly conflicts. I'm not sure.
No, you're so close. Why don't you finish it? Could he have sought a writ of mandamus in the lower court?
Yes.
Yes. Why?
Because that's what a writ of mandamus is. Like it's issuing against.
Yeah, exactly right. Very good. Thank you. He should have brought his case in a lower court. Had he done so, there would have been no question about the jurisdiction. All right? Now, why? We said this last week. I want to go back to Article 3. Right? Everyone take out your constitutions, right? Follow along at home. Okay, Article 3, where's my bag? Ah, here it is. So turn to Article 3, Section 1. It's on page Shout the page if you got it.
48.
48, thank you. Article 3, Section 1, page 48, right? The judicial power of the United States shall be vested in one Supreme Court, and in such courts as the Congress may from time to time ordain and establish. So we discussed, the Constitution creates the Supreme Court itself. But the lower courts, Congress can make whenever it wants. Right? Now skip ahead to Section 2, lower on the page. Right? And it says, I have it up here if you want to look as well. The judicial power shall extend to all cases of law and equity arising from the Constitution, in all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. Okay, let's stop with that sentence. Zachary, what does it mean for the Supreme Court to have original jurisdiction?
They can hear the case for the first time.
Yeah. Which parties can go to the Supreme Court for the first time? It says it. Read the sentence right there. Who can have original jurisdiction in the Supreme Court? List a couple people.
The ambassadors, public ministers, consuls.
Keep going, yeah?
Yeah, parties. The state shall be a party, Supreme Court, yeah.
Okay. So the Constitution says the Supreme Court can have original jurisdiction where there's ambassadors, public ministers, consuls, those are all basically ambassadors, and where a state is a party. So let's say, Zach, the state of Texas sues you, right? Say you really screwed up big time, right? Could they go to the Supreme Court right away? Or?
Yeah, because the state's a party.
Yeah. What if, like, you don't like Anthony, right? He did wrong to you. And you go and you file a lawsuit right in the Supreme Court, original jurisdiction. Can you do that? Okay. The Constitution lists a couple different parties that can go right to the Supreme Court and hear their case in the first instance. This doesn't happen much anymore. Usually the only cases that are in the Supreme Court's original jurisdiction today involve when one state sues another. Usually over water rights, right? So say like Oklahoma sues Texas over the Red River. This happens all the time. Where are the boundaries? And invariably the Supreme Court resolves those disputes. Okay. So there's original jurisdiction in these 4 or 5 cases. Zach, finish it up. Read the rest of the section. In all the other cases. Go ahead.
In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact exceptions, and under the regulations as Congress shall make.
Okay. So let's go on to Anthony, your bitter rival, right? Anthony, what does appellate jurisdiction mean? What's the difference between original jurisdiction and appellate jurisdiction?
Basically, all the other ones can be
Not the original?
Try answering the question without using the words original and appellate. What's the difference between original jurisdiction and appellate jurisdiction? Walk me through that. Case, what's different between original jurisdiction and appellate jurisdiction?
I guess appellate only comes after a ruling
Yes. A ruling where?
in the original jurisdiction.
Well, don't use original, but you mean like the lower court, right?
Lower court.
Yeah, I know what you meant, right. Here's the difference. With appellate jurisdiction, some other court had the first crack at it. Maybe it was a trial court, maybe it was someone else. The essence of appellate jurisdiction is that you're reviewing another judge, right? When you're sitting in appellate jurisdiction, you're reviewing what some lower court judge did. In contrast, original jurisdiction means you're hearing for the first time. No one had heard it before you. So Marbury sued in the Supreme Court's original jurisdiction, not its appellate jurisdiction. Or did he? So, is that Carlo? Carlo, we go back to Section 13 of the Judiciary Act of 1789. And it says the Supreme Court can issue writs of mandamus. Is that in its original jurisdiction or its appellate jurisdiction? Does it say?
The writs of mandamus, I believe, they can be issued.
Just the rule. I'm not talking about what comes later. Reading only this, and this is an excerpt, but it's enough for you to read. Does it say anything about whether these writs can be issued in its appellate or original jurisdiction? No. So how did Marbury read this provision then? How did Marbury understand it?
Well, he understood, or I guess he decided that it had to come from, the writs had to be issued, when you have, appellate jurisdiction and could not be issued out of.
No, I didn't say Marshall, I said Marbury. How did William Marbury, the disgruntled judge, right? How did he understand this provision? Did he think this applied in the original jurisdiction, the appellate jurisdiction, or both?
Oh, he thought it, well, definitely he believed it should, apply in original.
Yes. So here's the essence of the case, right? Marbury thought, he read section 13, it didn't specify appellate or original, that means apply to both. So he said that means I can go to the Supreme Court in its original jurisdiction and seek a writ of mandamus. Okay? Now go back here. Is that Kevin?
Yes.
Kevin, sir. So it lists here like 4 or 5 things: ambassadors, ministers, consuls, parties, which are states listed. Is mandamus listed there? It is not listed there. What significance does Chief Justice Marshall place in the fact that mandamus is not listed there?
That it should have, like a chief justice should have been like an ambassador, that he has higher power.
No, you're not answering my question. The opinion, Chief Justice Marshall's opinion, what does he make of the fact that only 4 items are listed here and not mandamus?
That it should be listed there?
No. David?
And it's like implied, or?
Can Congress add mandamus to this list of 4 or 5 items? No, David. Can Congress by statute add mandamus to this list of 4 or 5 items?
If it's not, I guess, directly contradicting statement.
What does Marshall say? I'm not asking your opinion. What does Marshall say? This was the holding of the case. You guys got to read more closely for first week. Evan, what does Marshall say here? Can Congress add mandamus to this listing of the original jurisdiction of the Supreme Court by statute? This is the entirety of the case.
Yes, I think that no. Yes, they can't, Congress cannot.
Why not?
Because didn't he say that Congress basically
This is holding. Adam.
That Congress only has the powers defined within the Constitution, and they can't add stuff to it.
Yes. Why can't Congress add to the Supreme Court's original jurisdiction? Adam, you're exactly right. Why can't they?
Because what would stop them from giving themselves more power than they were intended to have?
How do you change the Constitution?
It needs an amendment.
Can you do it by statute?
No.
There you go. Right. The essence of this case is that Congress cannot expand the original jurisdiction of the Supreme Court by statute. Congress cannot add to the Constitution itself by statute. The only way you can add to the Constitution is by an amendment. So what does Marshall do? Right, Brandon, is Section 13 of the Judiciary Act of 1789 constitutional?
Is it constitutional?
That's the question.
No,
Why not?
because it adds power to the courts that isn't in the.
Who's adding the power? Who enacts statutes?
The Congress.
And what do they try to do here? I just said it 3 times.
They try to add to the Constitution.
Yes, Congress tried to add to the Constitution by statute. They can't do that. Therefore, Section 13 of the Judiciary Act of 1789 is unconstitutional. It's a stunning holding that a statute passed by the first Congress, with many of the same people who helped draft and ratify the Constitution, that they were so sloppy as to basically violate the Constitution. Marbury is wrong for a lot of reasons. I don't think the statute is best read to say anything about the original jurisdiction. I think this means that where the court already has jurisdiction, the court can issue writ of mandamus, that is, its appellate original. I think Marbury should have lost, but not for these reasons. But the significance of this case is that Marshall established that courts could hold laws unconstitutional, but in doing so avoided any confrontation with Jefferson. Why? Jefferson won, right? Marbury lost. Madison won. There was no order to deliver the petition, the mandamus, right? So basically, Jefferson had nothing to ignore. So in the short term, Jefferson won, but in the long term, Marshall cemented that the courts can set aside acts of Congress. And this was the first time the Supreme Court had done this. And the court holds that an act that's repugnant to the Constitution cannot be the law of the land. And this most famous quote: "It is emphatically the province and duty of the Judicial Department to say what the law is." Right? Eric.
I realize this wouldn't have been as an exciting or as big of a deal if this would have happened this way, but since they already had it, the Judiciary Act already gave them the power to issue a writ of mandamus on appeal. Couldn't he have just dismissed the case?
Refiled it. Yes.
And then if he would have dismissed the case, no matter what the court below him said, it could have just come up to him and he could have reversed it on appeal.
So this is why this case is total BS, right? I don't say that point lightly. The correct answer to this case, right? You guys read about 15 pages. This case should have been one sentence: dismissed for lack of jurisdiction, Marshall, Chief Justice recused. That's it. That's it. Dismissed for want of jurisdiction, Marshall, Chief Justice recused. That's it. To my knowledge, Marbury never went back to the lower court and tried to seek a mandamus. Do you know why? Because Republicans abolished his positions, right? One of the first acts of the Republican Congress was to just destroy all of the Federalist judgeships. Talk about life tenure, guaranteed salary, they just destroyed them. So there was no position to even enter into, which is a stunning decision by itself. And by the way, the court upheld that, right? One of the judges whose salary was destroyed, called Stuart v. Laird, his salary was eliminated. He sued saying, hey, I have lifetime tenure, they destroyed my salary. And the court basically threw away the case. So in an actual thing that was unconstitutional, Marbury said nothing. Marshall said nothing. But here, where Marbury did the wrong thing, he filed in the wrong court, they struck it down. So this entire case is not to be understood as a correct application of law, but the establishment of very important principles in a tumultuous time. Yeah, I can't see your name tag. Okay, Crystal, yes.
I apologize. My question was, is the Judiciary Act of 1789 the same as the Judiciary Act of 1801? Are those
No.
the same documents? Or are they
No, different. The 1801 document was created by the Republican Congress, where they basically got rid of all the judgeships. Other questions? So I go back to our poll, which we took at the outset of class, and I asked you, are the decisions of the Supreme Court the supreme law of the land? And half of you said that was true, and about 54% said it was true, and about 46% said it was false. Huh. Amber, what did you put?
I put false.
Why'd you put false?
Because the Constitution is the supreme law of the land.
Ah, it's the Constitution. So let's go to the supremacy clause, right? Do I put it up here? I think I do. Okay, so Article 6, right? Flip through your constitutions. Article 6, it's on page 54. 54. And it says, this Constitution and the laws of the United States, which were made pursuant thereof, and all treaties made of which shall be made, under the authority of the United States, shall be the supreme law of the land. and the judges in every state shall be bound thereby. Anything in this Constitution or laws of the United States, the contrary notwithstanding. So then, Amber, what is the supreme law of the land?
The Constitution.
And what about the Supreme Court?
Supreme Court is just underneath the Constitution.
Indeed, the Supreme Courts are bound by it. Now, it's often said that Marbury established the principle that the Supreme Court's decisions are the supreme law of the land. It said no such thing. You read it 5 minutes ago. It said nothing about that. The court would actually reach that conclusion in a case called Cooper v. Aaron, decided during the Civil Rights era in the 1950s. But as you come ahead and you go through this class, think back to Marbury. And you had Thomas Jefferson, who thought that Marbury had no right to the commission. And had the Supreme Court told Thomas Jefferson, give him his paperwork, and Jefferson said no, would that have been correct or incorrect? Would Jefferson have been violating the Supremacy Clause? Would he have been violating his oath of office? Think about it. All right. Any other questions on Marbury? Okay. All right, we'll move on then. Thank you. The other 3 cases we'll be covering today are known as sort of foundational cases on the Marshall Court. And when I say the Marshall Court, I mean the court under the stewardship of Chief Justice Marshall. He was appointed to the Supreme Court when he was in his 40s. He was quite young. And he had one of the longest tenured Supreme Court history. I think he served 33 or 34 years, might be off by a year. And he presided over a remarkable change in the Republic. He was present during the ratifying conventions. He was a distant cousin of Thomas Jefferson. He outlived all of them. And he would be in the center of power for decades. And the 3 decisions I had you read, McCulloch v. Maryland, Gibbons v. Ogden, and Barron v. Baltimore, more or less define modern constitutional law. Each of these cases involves different clauses of the Constitution. We give them to you here in a chronological fashion, so you get the basis of how a republic began. And one thing to note is that even though Jefferson was Republican and had different values, Marshall remained a Federalist and Hamiltonian in many respects. So he was still pushing an older view of the world throughout his time in office. Okay? Okay. So the next case, McCulloch v. Maryland. Here, I can close this for a moment. Where is it? Here it is. So I'm sure many of you are familiar with the musical Hamilton. Heard about it? So I'll tell you this now, but I have tickets for it. I have 4 tickets. Whoever gets the highest score in the midterm gets a ticket.
Are you serious?
1 ticket. I have 4, so my 2 classes this semester, it's in April, it's ways away. So my property and ConLaw this semester and the same for next semester. Highest score in the midterm gets a ticket. So study. But I have season tickets. I saw it on Broadway years ago, so I already saw it. But this is your incentive. It's going to be sold out for a long time. Tickets are like years waiting list. But one of my favorite songs in the musical involves an important aspect of constitutional law, which is the Bank of the United States. So in the early days of the Washington administration, there was a question about whether Congress could charter a Bank of the United States. This came to the court some years later in the case of McCulloch v. Maryland. But the initial controversy was over whether Washington would sign into law. And you can imagine he had a cabinet that would put any other cabinet to shame. He had his Secretary of State, Thomas Jefferson. He had his Secretary of the Treasury, Alexander Hamilton. And they were always butting heads. Jefferson argued that Congress did not have the power to create a Bank of the United States. Hamilton argued that he did. And more often than not, when there's a dispute between Hamilton and Jefferson, Washington went with Hamilton. It must be nice to have Washington on your side, as the song says. So I want to play this song. This is called Cabinet Battle Number 1. It might be hard for you to follow the lyrics, but you can read along on the screen. And the setup here is you're having a debate between Hamilton and Jefferson about whether they can charter the Bank of the United States. So I'll play this here.
Ladies and gentlemen, you could have been
It's a great
anywhere in the
musical.
world tonight, but you're here with us in New York City. Are you ready for a cabinet meeting, huh? The issue on the table. Secretary Hamilton's plan to assume state debt and establish a national bank. Secretary Jefferson, you have the floor, sir.
Life, liberty, and the pursuit of happiness. We fought for these ideals, we shouldn't settle for less. These are wise words, enterprising men quote them. Don't act surprised, you guys, cause I wrote them. Now, but Hamilton forgets. His plan would have the government assume state debts. Now, place your bets as to who that benefits. The very seat of government where Hamilton sits.
Not true.
Oh, if the shoe fits wearing. If New York's in debt, why should Virginia vary? Our debts are paid, I'm afraid. Don't tax the South, cause we got it made in the shade. In Virginia, we plant seeds in the ground we create. You just wanna move our money around. This financial plan is an outrageous demand, and it's too many damn pages for any man to understand. Stand with me in the land of the free. Pray to God we never see Hamilton's candidacy. Look, when Britain taxed our tea, we got frisky. Imagine what's gonna happen when you try to tax our whiskey.
Thank you, Secretary Jefferson. Secretary Hamilton, your response. Thomas, that was a real nice declaration. Welcome to the present, we're running a real nation. Would you like to join us? We're staying mellow, doing whatever the hell it is you do in Monticello. If we assume the debts, the union gets a new line of credit, a financial diuretic. How do you not get it? If we're aggressive and competitive, the union gets opposed, you rather give it a sedative. A civics lesson from a slaver. Hey neighbor, your debts are paid because you don't pay for labor. We plant seeds in the South, we create and keep ranting. We know who's really doing the planting. And another thing, Mr. Age of Enlightenment, don't lecture me about the war. You didn't fight in it. You think I'm frightened of you, man? We almost died in the trench. Thomas Jefferson always hesitant with the president. Reticent, there isn't a plan he doesn't jettison. Madison, you madness or how does I take your medicine? Damn it, we're worse shape than the national debt is in. Sitting there useless as two shits. Hey, turn around, bend over, I'll show you where my shoe fits. Excuse me. Madison, Jefferson, take a walk. Hamilton, take a walk. We'll reconvene after a brief recess. Hamilton, sir, a word.
You don't have the votes. You don't have the votes. You're gonna need congressional approval and you don't have the votes. Such a blunder sometimes, it makes me wonder why I even bring the thunder.
Why he even brings the thunder? You want to pull yourself together? I'm sorry, these Virginians are birds of a young man, I'm from Virginia, so watch your mouth. So we let Congress get held hostage by the South? You need the votes. No, we need bold strokes. We need this plan. You need to convince more folks. Well, James Madison won't talk to me. That's a non-starter. Winning was easy, young man. Governing's hard. They're being intransigent. You have to find a compromise. But they don't have a plan. They just hate mine. Convince them otherwise. And what happens if I don't get congressional approval? I imagine they'll call for your removal. Sir, figure it out, Alexander. That's an order from your commander.
Okay, they all got that? We'll move to the next case then, right? No. I love that video. I used to play a clip from the John Adams miniseries, which you can watch later. It's a video here, but this one's much better. That video encapsulates the Bank of the United States debate in about 4 minutes, very well in an entertaining fashion with curse words, which better he says than I do. The question is this: does Congress have the power to create a Bank of the United States? This case arose in a very dramatic fashion. The first bank which Washington signed into law after this debate was wrapping, it expired in 1811. But following the War of 1812 between the United States and Great Britain, where they burned down the White House, Congress opened a second Bank of the United States. It was chartered and a branch opened up in Baltimore, Maryland. Maryland passed a law that said any bank that's not chartered in the state is subject to a tax. In other words, the state of Maryland tried taxing the federal bank. Okay? When Maryland tried to fine the bank manager, who's a cashier, James McCullough, $100, he refused to pay it. So they threatened to throw him in jail. McCullough challenged his prosecution, saying that the bank itself was that the Maryland tax was unconstitutional. So the case itself was, could Maryland throw this guy in jail for failing to pay the tax? But in order to determine that question, we have to reach the underlying question. Was the bank itself constitutional? If the bank was unconstitutional, then there's no problem, right? You can't fine someone for paying a tax on a bank that wasn't valid. But if the bank was lawful, could Maryland punish him? Could Maryland tax a federal bank? The Maryland courts, perhaps not unsurprisingly, ruled that he could be taxed and thrown in jail. The case goes to the Supreme Court. Back then, there were no briefs. Imagine that, no blue booking, nothing. There were 9 days of oral argument. 9 days, can you imagine that? This was a big deal. Daniel Webster argued for the bank. He was in the leading orators at the time. William Wirt, who served as President Monroe's Attorney General, Luther Martin. The case was decided 3 days after argument. In fact, it turns out that John Marshall was writing the opinion during the arguments. So he wasn't really paying attention. By the way, Marshall never asked a single question in arguments. He never did. People jump on Justice Thomas for this, but Marshall never said a word. So then the question becomes this. Does Congress have the power to set up a national bank? And if so, can Congress tax an officer of that bank? All right, these are our questions. So let's go to the text of the Constitution. David, you're up, sir. David, which article of the Constitution concerns the power of Congress? I need to know this cold. Which article of Congress concerns the power of Congress?
Article 1.
Yes, sir. Article 1. And refresher, what's Article 2?
Article 2 is the power of the executive.
And Article 3?
The power of the judiciary.
Yeah, very good. And you can remember this is alphabetical order. Article 1 is Congress, C. Article 2 is executive, E. Article 3 is judiciary, J. Easy to remember, never forget. You'll need to know this, cold. By the way, yeah, you can have your Constitution exam. It won't help you at all. It really won't. So, David, very good. So where in Article 1 are all of Congress's powers listed? Oh, beautiful, perfect, yeah. Article 1, Section 8, right? If there was a page called out. I think I got it. It's 34, bottom 34. Please bring these every class. If you lose one, I'll give you a second one, but not a third one. So try and hold on to them. I get these donated by the Cato Institute, where I'm an adjunct scholar. They give them for free, but I have tried to be judicious with how many I ask for. So Article 1, Section 8 lists all the powers of Congress. It lists Congress with the power to lay and collect taxes, to borrow money in the credit of the United States, shall have the power to regulate commerce among the several states. We read through this list in the last class. Very good. Is that Boone? Boone, is there a power listed in Article 1, Section 8, a power to create a bank of the United States?
They don't list a power to create a bank, but it's drawn from the power to lay and collect taxes with any tools necessary and proper.
Oh, what a good answer. It's exactly right. There is no specific reference in the Constitution to the power to charter a bank. But if we read all the way down to the bottom, Clause 18, if you want to number them, right? To the bottom of page 37. And it says, Congress shall have the power, right? Congress shall have the power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all their powers vested by this Constitution in the government of the United States or in any department of officer or officer thereof. Jackson, what does that mean? What I mean, I just read it, it's up here. What does it mean? By the way, these are the pictures from the cast production of Hamilton. Really good show.
It's basically like they have their powers that are listed out, but this can kind of like expand on what's not necessarily.
Wait a minute. What do you mean expand, right? Aren't all of Congress's powers listed? It says it right there.
Right.
All legislative powers herein granted. Didn't we just say in Marbury 5 minutes ago that Congress can't expand their powers, that they're fixed to what's listed there? How can Congress expand its powers? It says nothing about banks. It's not listed anywhere there.
Well, it'd be kind of impossible to list everything. Like you could never move forward with the future. Like if you just had everything listed right there, you'd need to be able to look at what you already have written down and if it related to that.
Related? Oh, where do you get this related word? That's a good word. Brittany, where do you get this related word from?
Basically, the power that they're given, I wouldn't say they're general, but they're more general because you don't know what's going to come up. You don't really know everything to expect. So they're giving them basically the power to create other powers to help them to enforce what they're already able to do, the enumerated, the ones that are already listed, right? Whatever they need to do to execute those.
Whatever. Now, you said related. You said whatever. Well, which one is it?
It's related.
Related? Melissa, what do you think?
I think they use the example about commerce.
Okay, good. Give me a talk about commerce.
So you can have commerce, but you need someone who sends something. You need the recipients, and you also need traveling by means.
Good. So the three of you all use slightly different words to describe the fit, if you will, right, between what Congress wants to do, its ends, its goals, and the means. This is a common theme in constitutional law, the fit between the means and the ends, right? They want to have a bank, and the Congress gives them the power to regulate commerce and collect taxes and do these sorts of things. How close is the relationship, right? How close is the fit between the means and the ends? So, Kelsey, I'll give you another example. Congress has the power to create postal roads, right? That's in there. Does the Constitution say anything about buying horses and buying wagons and hiring mailmen and these sorts of things?
No.
But
they're saying that they have the power to.
You're on the right track. Keep going. What does it say?
Necessary and proper. Those
For what?
things are necessary.
Necessary and proper for what? Keep reading.
For hearing and execution of foregoing.
And what is one of those foregoing powers?
The postal.
Yes, that's exactly right. Congress has the power to use all laws that are necessary and proper to carry into execution the other powers listed in Article 1, Section 8. So when they want to create postal roads, when they want to regulate commerce, when they want to tax, when they want to establish courts, they can do additional things. They can make other laws that are necessary and proper for carrying those other powers into effect. So it's not expanding the scope of government. The government itself says, or the Constitution itself says, they can do that which is necessary and proper to get there. Okay? So is that a Portland? What does necessary and proper mean? That's our next question, right? What's necessary and proper? Yeah. Well, take it one at a time. What does necessary mean? Let's break it down.
What's needed?
Needed. So use, I feel like I'm back in the LSAT. Use necessary in a sentence, right? Give me necessary in a sentence.
It's necessary to study to do well the midterm.
Good. Okay, I like that. Yeah, it's necessary to study. Can you do well without studying?
I'm not going to go law school with that.
Well, let's say you're a genius, right? I'm sure you are, right? Let's say you're a genius and you can just sit here and listen in class and like soak in like a sponge. Is it absolutely necessary to study for an exam to get an A?
No, sir.
No, but it's probably a good idea, right? So we have these words, right? We have necessary and maybe absolutely necessary. See the difference, right? I can't read part. Mark, how does Marshall read or understand the word necessary? Does he think it means absolutely necessary or maybe conducive to or helpful? How does Marshall describe necessary? What meaning does he give it?
When made in pursuance of the Constitution.
No. How does he define necessary?
That it would be absolutely necessary.
Is that what Marshall holds?
No, he said it's only lightly necessary.
Lightly necessary, right? Yeah, good. I can't see it. Crystal, what synonyms does Marshall use to describe necessary? What other words does he use to describe necessary? He does not use absolutely necessary, that's right. What words does he use?
I don't know exactly what words, but it was like conclusively necessary, not absolute.
But something less than that, right?
Less than that, yes.
Yeah, the word which I think he uses is convenient. Convenient, right? If it's convenient to Congress to charter a bank in order to more effectively regulate commerce and lay and collect taxes, that's all that's needed. He rejects the idea that it has to be absolutely necessary. Indeed, in the debate between Jefferson and Hamilton, these two guys, right, back in the 1790s, Madison and Jefferson said absolutely necessary, right? Unless it's absolutely required, Congress can't do it. And Hamilton said, no, be flexible, right? If it's convenient and it's helpful, then they can do it. If Congress wants to have a bank and they'll help them have money in different places and have currency available and collect taxes in each state, they can do that. So here, once again, Marshall is ripping off Hamilton. Marshall plagiarized Federal 78 in Marbury, and here, Marshall's plagiarizing Hamilton's defense of the Bank of the United States. So under our laws, necessary simply means convenient. As long as some other incidental power helps Congress get to where it wants to go, that is enough. It's convenient for them. Understand? Everyone with me? So this gives Congress a lot of power. Even though they're acting under their power to regulate commerce and to collect taxes, this is really a necessary and proper clause case. In fact, most cases you study that involve the Commerce Clause are actually necessary and proper clause cases. You'll study cases about regulation of agriculture, regulation of drugs, narcotics, regulation of violence, regulation of guns. Those aren't straight up Commerce Clause cases. They are almost all Commerce plus necessary and proper clause. You see, the necessary and proper clause doesn't give power by itself. It only gives power when it's combined or linked with another enumerated power. So you can have Commerce plus necessary and proper clause, right? So if the Commerce Clause is here, necessary and proper clause is here. If you have the power to tax is like this, and then power to tax plus necessary and proper is like this. It expands the scope of powers through this so-called elastic clause. That's what I call elastic. It stretches out the power of these enumerated powers. Everyone understand? There's two words there, though. We've only been talking about necessary. Eric, what's the other word we got there?
Proper.
Proper. What does proper mean? Does Marshall spend... Does he really focus on proper at all?
Not very much. Just simply to say that it can't be an egregious type of thing. Like you couldn't say, going back to the post office incident, if it's necessary for them to buy horses and stuff like that, it's not maybe necessary, or it's not proper for them to go beyond that scope.
Like, could the post office, acquire fighter jets,
right?
Deliver mail by dropping it from the sky? Probably not. So Marshall has like a couple sentences on proper. I'm only going to flag it here because when we come back to the Obamacare case in a couple weeks, it'll be important. Marshall writes that the necessary and proper clause can't reach, and this is a quote, a great and substantive independent power, which cannot be implied as incidental to other powers or used as a means of executing them. I'll say it again. The necessary and proper clause cannot reach, quote, a great and substantive independent power, which cannot be implied as incidental to other powers or used as a means of executing them. You ever hear the expression, the tail that wags the dog? You know what that means? All right. I'll give you the example from Obamacare. Under the Affordable Care Act, there was a requirement for people to maintain insurance, people to buy insurance. What was Congress's argument? Well, if people don't buy insurance and they go uninsured, when they get sick, they'll go to the ER and they'll shift costs to everyone else, right? So the regulation of commerce is a regulation of the interstate insurance market. But the actual mandate itself required people to buy health insurance. And the Supreme Court said by a vote of 5-4 that that was a great and substantive independent power. That is, the power to make people buy insurance was such a bigger deal than just regulating insurance markets that it went too far. This is one of the only times in 200 odd years that the court found a law to be necessary but not proper, right? Having this mandate was definitely convenient to regulating a healthcare market, but it was not a proper means of doing so because it made people buy insurance, which that had never been done before. So don't forget that it's two things. It's necessary and proper. It's not just necessary. Far too many law professors who were surprised by the outcome in the Obamacare case didn't pay attention to this part of the decision when they were in school. Okay. So the bottom line, right, the bottom line of the case is that the Bank of the United States was constitutional, that Congress's powers to regulate commerce and to lay and collect taxes, in order to do that, it was both necessary and proper to charter a bank. Now here comes the second part that's not clear. Martin. Because the Bank of the United States was unconstitutional, because the Bank of the United States was constitutional, what happened to Maryland's law? What happened to the fine on the bank manager?
It had to go.
Why'd it have to go?
Because by saying that it's constitutional, that override.
You're right, keep going, you're exactly right.
It overrides Maryland's law under the supremacy clause.
Exactly. We go back to our favorite clause, Article 6, Clause 2, the supremacy clause. The Constitution and the laws of the United States. So here we're not dealing with a provision of the Constitution, we're dealing with the second part, laws of the United States. So the laws of the United States shall be the supreme law of the land. Anything in the laws of any state to the contrary. What does that mean, Martin?
You can't contradict. I mean, you have to have one or the other. If you've got two things that are saying the other, or two things that are saying different things about the same thing.
Mm-hmm.
No, I'm playing the pronoun game. Sorry.
Take your time.
And if it's constitutional, then things that are laid by Congress that are constitutional will override state laws.
Very good. Under our supremacy clause, a federal law that conflicts with a state law, the state law is what's called preempted, right? Here, I'll write it out for you. Preempted. A state law that conflicts with a federal law is preempted. It's null and void. If the federal government seeks to regulate an area, states are displaced. They cannot do it. So because the bank is constitutional, Maryland's attempt to tax it is unconstitutional. Marshall writes in the opinion, the power to tax is the power to destroy. And if a state institution can tax a federal bank, they can put it out of business. That cannot stand. So as a result, the bank manager, McCullough, does not need to pay the fine. Now, is that, how do you say your name, Bahara?
Bahara.
Bahara. Can a state charge property tax to a post office that's in their city? Well, why can a state charge a property tax to the post office down like Westheim or whatever, but they can't charge a bank tax?
Well, it's within their.
Oh, they're both taxes? Why can they charge a property tax, but they can't put a tax on the bank itself? There's not a good answer to this question. I don't mean to pick on you. Marshall kind of fudges it. He says, well, the state, of course, has the power of taxation, but this is different, right? Because this is a tax designed to put the bank out of business. And you can't have a state function designed to destroy a federal function, right? Everyone with me? All right, any questions on McCullough? Yes, sir, Jackson?
Going on what you just said there, so why not? There's not a good answer, so is it just like
This is a special case where you literally had a state trying to shut down a federal institution. This was not a generally applicable tax. Like, for example, if you're living on a block on Westheimer Road or whatever, every business pays the same property tax, right? This is a tax designed only for a federal institution. So this was designed to put out of business. I think that's the answer. Yeah, the bank was somewhat unpopular in a lot of states. They were basically trying to shut it down. Yes, Ashley.
So, to answer the question that you asked before, the reason why you can do, or they can have a tax property is because they're not intentionally trying to shut down.
I think that's the answer. Marshall kind of fudges it. He doesn't really answer that question. I mean, I posed the question, of course, but Marshall somewhat tap dances over the issue about whether a state can tax. Because usually a state has the power to tax, and if there's a post office and they want to charge a property tax, they can probably do that. But it can't be used to destroy the federal institution. I think that's the key point. Epper?
So if they were, say, taxing the post office just for being a post office, then that
So if
would
the
be-
city of Houston imposed a special tax on post offices in Houston and no one else had to pay, that would probably be unconstitutional, I suspect. Kevin?
Could the tax for property be because the property belongs to the state?
Well, the post office can buy it or lease it, whatever happens to be, but if they buy the property, it's theirs just the same. Anything else, McCullough? This case, the significance of it, it can't be understated. Had the other perspective prevailed, had the Madison, Jefferson perspective prevailed, Congress would have been very much constrained in what they could do. Most of the regulations in the 20th century are premised on the Commerce Clause. Virtually everything the federal government does is by a regulation of interstate commerce. If Congress was limited to only that which is absolutely necessary, it's unlikely that a republic could have grown into the industrial place it was. Maybe we would need an amendment, maybe something else would have had to happen. But Marshall, the Federalist, saw decades ahead, and he recognized that Congress needed to have this vision. Whether it was a correct interpretation of the Constitution is largely secondary, but that is the Blackfoot law that we have. Any questions on McCullough? All right, let's move on to Gibbons. So Gibbons v. Ogden concerned a dispute between this guy, Thomas Gibbons, and this guy, Aaron Ogden. And it concerned a dispute over ferry boats between New York and New Jersey. Okay? Again, this was not a direct challenge to any sort of federal law. Rather, you had a dispute where New York said, we're going to give this one guy a monopoly, and only he can drive ferry boats back and forth to New York. And this other guy said, no, 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 you can't have that monopoly because Congress sought to regulate interstate commerce. What? In other words, it's a similar issue as McCullough. If Congress passes a statute that regulates boats going from state A to state B, can a state regulate it just the same? The answer from McCullough is no, right? So as it stands now, there's preemption. the New York law would be preempted by the federal law. But that's not why I made you read this very long and boring case, right? There's another reason why. Ashley, why did I have you read this case? And don't say cruel and unusual punishment, that's not the answer.
That's what I'm thinking.
Why did I have you read this case? What's the significance of this case?
That the law granting the monopoly violated the Constitution?
You're right, that's true. Why did the law granting the monopoly violate the Constitution? Let's try it that way.
Because it limited.
Limited what? Got the right track. What was the effect of the monopoly? That you couldn't bring a boat from New Jersey to New York unless you had a license from the state. What was the effect of that law? Why was it unconstitutional? All right. Actually, let's try it another way. Go back to Article 1, Section 8, okay? Commerce Clause. I have it on the board right over here. Read the Commerce Clause, please.
Congress shall have power to regulate commerce with foreign nations and among the several states and with Indian tribes.
Okay, so let's start with what Congress can't do. What can Congress not do under this? What sort of commerce can Congress not regulate?
Federal commerce?
Well, they can regulate it among the states. What kind of commerce can they not regulate? Emily?
Inside the states?
Yes. Congress cannot regulate commerce that is entirely within one state. Right, Emily? So what's here the magic word, right? What's the word that we have to fight over to understand?
Among?
Among. What's among?
Within two different states and their boundaries.
Okay, good. So if I were to poll, and I'm not going to do the polling thing again, but if I were to poll you again, if I just ask you, what does it mean for commerce among several states? How many states would have to be involved, Emily?
I'm sorry?
How many states would have to be involved to say among the states? At least?
At least two.
At least two, right? My reading, and I've read this document more times than I can count, is that commerce among the states means among at least two states, right? Shivan, how many states are involved in this deal?
Two.
Which states?
New York and New Jersey.
Good. How do we know that there's literally two states involved? I mean, I'm being pedantic here, but how do we know that?
Here's the facts of the case tells that.
What are the facts of the case?
That
Where are the boats going?
across the water.
From New York to New Jersey, right?
Yeah.
So this is literally, right, and actually a case where you have boat going from state A, New Jersey, to state B, New York, right? So Shivan, is there any doubt in your mind that this is commerce among the states?
No.
Okay. But Marshall doesn't quite stop there. He never does. He always goes too far, right? Further than he should want to, right? Brittany. Oh, we got two Brittany's in a row. This is going to be confusing. Okay, Brittany.
We did it on purpose.
I bet you did. I've had that before. People with the same names sit next to each other. It drives me crazy, but I'll do my best. It's okay. You can say what you else, fine. So Brittany, if I point and you just be on where you are. Okay. So Brittany, how does Marshall then define among? What definition does he give to the word among? Louder, I couldn't hear. I'm sorry.
Intermingled with.
Exactly right. What does intermingled with mean? What does intermingled with? Mixed. Oh, I love these words, right? What does? Give me more. What does it mean to have commerce intermingled or mixed? What does that mean?
Well, I mean, I kind of imply from that is that if you're going from the boundary of one, and I think he says the boundary of one state to the boundary of another, right?
Ah. Is it only within one boundary to another?
No, I think it'd be multiples, but
Kelly, what do you think? How does Marshall define mixed or intermingled?
A thing which among others is intermingled, cannot stop at the external boundary line.
That's the quote. That's a money quote. Please read it one more time, please, so your classmates can hear it. Just read the exact sentence one more time.
Commerce among states cannot stop at the external boundary line of each state, but may be introduced into the interior.
So what if the boat starts off in New Jersey, goes into New York, makes a pit stop, and then goes up the Hudson River to upstate New York? Is that among, according to Marshall's definition? Yeah. So what we have here, right, is the idea that Congress's power to regulate commerce doesn't stop at the border, right? It doesn't only mean boat going from shore to shore. It also means boat inland going within a state. It is a river within a state. Why, Jay or Jai? Jay, thank you. Just write that phonetically later, so I want to make sure I get your name right. Jay, why is that significant that Marshall defines it as intermingled with beyond the borders? Why is it significant?
Well, I would think if you stop at the external boundary of each state, then it would promote more of a issue with commerce, with commerce being involved with both states. So it would in essence, I guess, one state would have more commerce opposed to.
Well, you're on the right track. Let me ask the question differently. If Congress can regulate commerce beyond the borders within one state, what does that do to the state's powers?
Minimize pollution.
Where Congress, say Congress passes a statute saying after a boat crosses shore and goes 5 miles, we're going to impose a tax on that boat. We're going to regulate it. Can the state regulate that as well? Why?
Because the state has powers only within that state.
Well, but Congress is regulating stuff within that state. Once Congress regulates commerce within a state, what does that disable the state from doing?
Exercising its powers.
Why? What clause?
The supremacy clause?
Yes, the supremacy clause, exactly right. Thank you. The bigger Congress's power gets, the smaller the power of the states gets. Did you discuss in property the concept of the police power?
We're just starting.
Oh, I always forget. I have no conception of time. In other classes, you have the concept of the police power, right? This is the power of the state to regulate the health, safety, welfare, and morals. Congress has limited powers, but the states, such as Texas, has very broad police powers. As Congress's powers increase, the state's police powers shrink. So the more Congress can regulate inside the state, the less the states have their own autonomy. So what Marshall's saying here is Congress can do more than regulating a ship going from A to B. They can regulate the ship once it goes within a state. And that doesn't just apply to boats. It applies to railroads in the future, carriages, and other forms of commerce. So that's why this decision is so significant, this intermingled with. Because again, Marshall said, wait a minute. If we limit Congress's powers to boat going from point A to point B, that's not very much. But once we say it's within the state, that's a big deal. That's the quote from Legally Blonde, right? Rosario? The law is reason free from passion, Aristotle?
Yeah.
You ever seen Legally Blonde? That's the first time I've ever heard that quote, so I appreciate it. So, Rosario then, can you discuss what among means? What's commerce? What is commerce? This is a question that will bedevil the court for to this day. Oh, come on. That's the entire crux of the case. What is commerce? I'd like to see notes. I don't have it.
I've read a lot.
Almost done. We'll get there, I promise. What is commerce? Your name tag tipped over? Right here? See? Oh.
Adiami.
Adiami. What is commerce?
Sorry.
What is commerce? How does he define commerce? How does Marshall define commerce? John?
It's trade, but also traffic.
Well, he uses a word, he uses an I.
Oh, well, that's when I went into like navigation and that.
He uses one word because of an I.
Not it's traffic, but it's something intercourse.
Well,
Sorry.
yeah. Intercourse, right? And don't, Herbert, shut up. What does, Adiami, what does intercourse mean? Keep it PG.
It describes the intercourse between nations.
Don't laugh.
Pretty much, I would say that based on what I read, I would describe intercourse is that their interaction with each other or they're going with
Yeah, interaction, that's a good one, right? Intercourse, interaction, the exchange of stuff, right? So, Marshall doesn't see commerce as restricted only to economic activity of, buying and selling, but the general exchange of goods. The definition of commerce will be expanded much more later, but here we're already seeing commerce being used in a fairly expansive fashion. I'll give you a preview the rest of the semester. By the 1980s, commerce comes to mean whatever Congress damn well pleases. And I'm not exaggerating. Whatever Congress wants to regulate, that's commerce. And if it's not commerce, with a necessary and proper clause, you too can regulate it, right? So once you take a definition of commerce that's really broad, and you lump it together with the necessary and proper clause, Congress could do whatever it damn well pleases. And it wouldn't be till the 1990s, when some of you were alive, that the court would actually recognize limits on Congress's enumerated powers. Okay? So the crux, right, the two important points of Gibbons v. Ogden is commerce basically refers to all intercourse, whether it's commercial in nature or not, and among means not only between two states, but within, intermingled with one state. So when you combine McCullough v. Maryland with Gibbons v. Ogden, you start seeing the seeds of how this new central government would have a broad power of regulating all manner of activities between the states and eventually within the states. Okay. Questions on Gibbons? Questions on Gibbons? No? Okay, last case, I'm sorry. Barron v. City of Baltimore. So we read the entire Constitution last week, or last class. And the First Amendment began with the phrase, Congress shall make no law, blah, 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 right? Rachel, without any doubt, which branch of government is controlled by the First Amendment? Which branch of government is restricted by the First Amendment?
The federal government?
Yeah. How do you know that? First word.
Congress?
Yeah. So who is prohibited from making laws respecting establishments of religion?
Congress.
Can the states? Can the states establish a religion?
Now they cannot.
Now they cannot, but at the time of the founding, were they allowed to?
Yes.
Indeed they did. I think half of the states in the Republic had an established church at the time of the framing. Could states punish the freedom of speech?
Yes.
Could they shut down newspapers?
Yes.
They did. If a state wanted to give its citizens certain rights, what could they do? Like say a state wanted to protect the free press in Maryland or Virginia or in Pennsylvania, what could they do?
Couldn't the state create its own Bill of Rights?
Yeah. And in fact, most states had their own constitutions.
Mm-hmm.
Texas is a constitution. Texas is a Bill of Rights. So states can create their own Bill of Rights. But there's another provision of the Bill of Rights, says the Fifth Amendment, which says, nor shall private property be taken for public use without just compensation. Lacey, does this provision specify whether it applies to the federal government, the state government? Does it specify?
No.
No. So what are we supposed to do with this?
Talk about
Yeah, let's talk about it. So how does Craig Barron
Okay.
read the Fifth Amendment? Does he think it puts limits on the state of Maryland's actions?
Yes.
Why does he think that?
Because he just thought that it applied to all the states.
Yeah. Very good. So we have the case of Barron v. Baltimore. Oh, you thought you were off the hook. You're back up. Can you read this one either? Did you read this one? Honestly? Okay, good. So what happened in Barron v. Baltimore?
Marshall.
No, I do the facts. You're jumping way too far ahead. What were the facts?
It was about a fishing wharf and the state of Baltimore redirecting the water and causing the wharf to get dry so this guy couldn't run his ships or something.
Very good. Right. So the city of Baltimore did some repairs, some maintenance with the wharf, which is by the water. And as a consequence of that, it flooded this guy's wharf. All the sand came in, and his dock became too shallow. And as you know, when the dock is too shallow, you can't bring any boats in there. So he said, "Hey, wait a minute! You guys took my property, and you didn't pay me for it. So pay me." Now, Maryland did not have in their own state constitution a takings clause. So this guy went to federal court and brought a lawsuit arguing that the federal constitution protects his rights. He wanted compensation from the state of Maryland. Now, I want to pause here briefly. This is what's known as a regulatory taking. Did they actually take his property? Benjamin, did they actually take his wharf away from him?
No, they just made it unusable.
They reduced its value, right? The Supreme Court would not recognize the idea of a regulatory taking for another 100 years. The idea that when the government diminishes the value of your property, you can get paid for it. Okay? So he goes to court and says, "Hey, Fifth Amendment, give me takings, right? Give me compensation." Jessica, what does Mr. Marshall once again say?
He says that
Okay, now, I'm very critical of Marshall and his other opinions. I think they're probably all wrong. This one I think is correct, right? What evidence is Marshall to support the fact that the Bill of Rights does not apply to the states? What evidence does he cite, Jessica? He has actually some decent evidence here.
that the amendments don't express an intention to apply to the state.
Good, how do we know that?
You're
exactly right.
They just don't say it.
Yeah, good. So the amendments by themselves say nothing about the states. Indeed, the First Amendment specifically applies to Congress. Is it Daniel again? What other evidence is Marshall to get there? He cites a few different arguments I think are actually quite compelling by text. There's a very good textual argument he raises.
They could require changes to these?
Yeah, if a state wants to compensate takings, they can amend their state constitution. It's perfectly within their power. And Daniel, what's easier, to amend the federal constitution, to amend the state constitution?
State.
Yeah. So if the people of Maryland want this, they can do it themselves. Okay. Is that Andrew? Well, give me another reason that Marshall gives.
When he, let's see, I want to say when he says that the,
Here, this is running short on time. I'll give you a hint.
yeah, please.
Look at the two provisions on the screen. Article 1, Section 9, and Article 1, Section 10.
Well, yeah, he says,
Oh, there it is. Okay, good.
that it contains restrictions. Is that?
Jonathan?
Getting more?
Okay. What are the significance of these two provisions to understand why the Bill of Rights does not apply to the states? Remember what a Bill of Attainder is, Jonathan? Does anyone remember what a Bill of Attainder is?
that creating a law specifically for one
Yes.
main person?
Bill of Attainder is a law enacted that punishes one person. So instead of having a judge and jury, you have a statute, right? Jonathan, does the Constitution prohibit bills of attainder?
Yes.
Okay. In Article 1, Section 10, who's banned from having a bill of attainder? Which branch of government? On Article 1, Section 10.
Says no state shall?
Okay, so states are prohibited from doing it. What about Article 1, Section 9? Congress. So this is Marshall's argument. You have the same prohibition twice. In Article 1, Section 9, Congress cannot impose a bill of attainder. In Article 1, Section 10, the states cannot impose a bill of attainder. From this he derives the rule that when the Constitution speaks to Congress, they say it. When the Constitution speaks to the states, they say it directly. So because, right, there is no express reference to the states in the Bill of Rights, it cannot apply to them. And if the states want to compensate their citizens, they can, but not by the federal Constitution. Okay, so everyone get the holding of that case. Of all of Marshall's decisions that were wrong, and this one was right, this was the only decision that was overturned. The original design of the Constitution was to basically let the states do as they please, with the understanding that the states had the interests of their people in mind. Of course, the issue of slavery proved that that wouldn't work out, and that the states would routinely violate the rights of slaves within their borders. And it was only after the ratification of the 14th Amendment in 1868, and then some decades later, that the courts would start to extend or incorporate the Bill of Rights to the states. And with that, over the course of decades, the court would find one right after another. The First Amendment, the Third Amendment, First Amendment, the Fourth Amendment, the Fifth Amendment, were all extended to the states. But the decision of Marshall here ensured that the guarantees of the Bill of Rights would not protect any people in the states, primarily including slaves. Questions on Barron v. Baltimore? Yeah, Carlo?
Okay. So what you just said right now, that kind of threw me for a loop. So
whoa.
You just said that when he said that the Fifth Amendment did not apply to the states, that was later overturned?
Oh, it was. You know how it was overturned? By the amendment process.
Right. But it wasn't overturned in our reading. We didn't see it in this case. Okay.
Nope. I'm giving you what happened later.
I thought I missed it.
No, you didn't miss anything. So let me try to summarize. Why are these four cases grouped together? Well, the easy reason, they're all John Marshall decisions, right? But more importantly, these cases lay the foundation for the growth of our republic. They establish the power of Congress to regulate commerce, the scope of the necessary and proper clause, the power of Congress to regulate inside states, and whether states can have their own powers limited by the Constitution. And Marbury is the umbrella that ties them all together. And that Marbury asserted that the court would step in to intervene to invalidate unconstitutional laws, but only when it wanted to, not when there were actually unconstitutional things. Any other questions? Okay, if you had problems with the app, please come up, and I will see you all on Tuesday. Thank you so much.